And do we have Ms. Flick or Mr. Bondurant with us as well?
I'm here, Your Honor.
Yes, my client is present.
Let's see, we have a couple people logging in. Let me admit the waiting room here. Okay. So on Monday, we did receive notice of appearance of an attorney in this matter. Ms. Bliss is online. And my instructions in these types of situations is to get you guys set to the represented docket. Is there any objection to that, Ms. Bliss?
No, Your Honor, I did just notice that there's also a hearing scheduled next week in front of Your Honor, so I would just ask that that gets set over as well, if Madam Clerk can do that.
Okay. Let's log in here to give me a second just to get your digital file open. Mr. Bondurant, are you expecting to retain counsel at this point?
Yes.
Okay.
Okay. In the meantime, so I haven't seen still one of my kids in a month and a half, and Friday's coming up. I'm supposed to be retaining my children. So how's that going to work? I do not feel like I should be going all through these court dates without seeing my kids.
So I'm moving you to next Tuesday. I'm not going to be taking any action on the case today, and you can address that with the judicial officer on Tuesday. I do want to ask, because my ruling last week was that that Riley be returned last week. Did that occur?
Yes, Your Honor, I do believe that occurred right after the hearing.
Okay. And then you also have the motion for contempts, both motions for contempts on for August 30th. We'll move that motion also to August 29th. Will that work for the court? Yeah. Okay, so we'll get both of those, today's proceeding and your August 30th proceeding, both consolidated. Heidi Etler and Christopher Etler. And I have Ms. Turnbull on that. Good morning.
Good morning.
And Casey Looney on behalf of the state as well, Your Honor.
Good morning.
Good morning.
So originally, when we were here on August 9th, I was informed that there was potentially an agreed parenting plan, and we were going to use today as presentation of that. Is that still where we're at? I don't see anything in the file. I see a declaration.
I submitted
about what parties are, hold on, about what parties are requesting, but let me just go ahead.
I submitted the parenting plan last week on Thursday.
Okay. I do have an original order here, a final order and findings on petition to modify child support. Ms. Looney, has your office been served with these documents?
Your Honor, we submitted a proposed child support order and worksheets. We did receive a copy of a proposed parenting plan from Ms. Johnston, but the form of the parenting plan doesn't align with what I believe the parents intend as far as the split of custody. And so I don't know if Your Honor has that copy.
Yeah, I'm looking at this. Do we have Mr. Etler online with us?
Yes.
Okay. Sir, I have a document here that proposes to have your signature on it. And first, I'm just going to talk about the parenting plan that's been filed. Have you had a chance to review this?
Yeah, I went over it with Heidi, yeah.
Okay. You have signed this. Are you in agreement with this?
Yes.
Looking at the declaration here. But then I guess Ms. Johnston, I am a little confused by the declaration that you have filed in comparing that with the parenting plan that you purport to have provided to the court to sign. So help me out here on what your objective is.
So that was for Cadence, which is my youngest, which is at Dad's house. And that's supposed to be every weekend and every Wednesday. And she's all the kids are just staying like mental health services. And then so my 13-year-old doesn't want to go to Dad's house, and that was also put in there.
Have you guys used the court facilitator to look at your final orders? Because what you're submitting to me doesn't, the declaration and the parenting plan, and then the petition to modify child support, it doesn't all mesh.
And Your Honor, the state did not receive a petition to modify child support.
Okay.
So I don't know what that document would contain.
Right. Yeah, it purports to be a parental agreement modifying child support, which I'm just not sure this court can enter given the state's involvement. So
No, Your Honor, one of the children is receiving TANF, so we wouldn't be able to agree to a change to what we proposed.
I don't have, so folks, I really just don't have here the type of documents I could in good faith enter for you. What I'm going to encourage you to do, I'm going to give you a new court date. I'm going to ask for some input from the clerk here in a second. A great service that this courthouse has is a courthouse facilitator that can meet with you to go over and review your final orders before they come to me to make sure the court can actually enter them and that it does comply with what you're asking for. Understand when you're not working with an attorney, this can be very difficult. Actually, Ms. Turnbull, we do have you on this case, don't we?
Yes.
Would you be able to help the parties just get the information to have their paperwork reviewed by the courthouse facilitator here before our next hearing?
Absolutely.
I think that would be really beneficial because I don't even think I have all the final orders that I would need. About how far out are the facilitators right now? Okay.
It's $20.
Okay. So it is a $20 fee. You come in with your final orders and you schedule that appointment. So if you all did that in the next 2 weeks, and let's say the courthouse facilitator is about 2 weeks out, I would be looking to set you on probably to be safe. I would say Wednesday, September 27th to have you all come back here. That'd give you a little over a month. So when you have the final orders, you come in, pay the $20 and make an appointment. And the appointment with the facilitators it's always on a Friday.
Okay.
Okay.
Do they make this appointment with the clerk?
Ms. Turnbull's asking if they make that appointment with the clerk? Yes. Just they're telling me it's at the front counter. They would walk up and make the appointment.
Okay.
Okay.
Thank you.
So we'll get you moved over to September 27th back on this docket at 9 a.m. Again, when you get those final orders reviewed by the courthouse facilitator, please make sure Ms. Looney's office gets a copy of those, okay? Burkett
Thank you.
and Shane Llewellyn with me.
I'm here, Your Honor.
Your Honor, if I may intervene,
Please.
I had email contact with Tasana Burkett yesterday. She received 40 days in jail that started today as the result of her DUI car crash that occurred a couple of years ago.
Okay.
And so she's not going to be available today.
So thank you for that. Our initial reason for being on today was to review that potential sentence and how it may impact parenting. What is happening with child while she's serving this sentence, or do we know?
I do know, Your Honor. She was living with her parents in Woodland, and so Abel is with her parents at this point. And should she serve out the entire 40 days, her release date would be October the 2nd.
Okay. So, Mr. Llewellyn, were you aware of this information, or is this new to you?
I'm aware. I was under the impression that it was 90 days, but apparently 40. That's even better. So
Okay.
Abel can have his mom back in his life sooner.
Okay. Are we, the last thing we have on file is the visitation order of June 8, 2023. My inclination, as it does sound like child is in a safe place, is to just set this review matter out to a date when Ms. Burkett can be present. Or do Mr. Lawrence or Mr. Llewellyn have concerns about us needing to address the child's placement for these 40 days?
Your Honor, I would like to speak up. I have not seen Abel. I was allotted 36 hours with him, and I maybe see him 10 hours a month because of the supervisor.
Mhm.
She has to take care of her mother-in-law, as well as she works bartending gigs and weddings.
Mhm.
So she never really knows when she's available. And I have, so from Saturday, June 10th and 11th, I got 4 hours both days, which I'm supposed to get 8. Saturday the 24th and 25th, both days I got 0. Wednesday the 5th and 8th, as well as Sunday the 9th, I got 0, 0, 0. Wednesday the 19th, 22nd, and 23rd, I got 0, 0, and 4 hours. And then I got 0 hours, 0 hours, and 0 hours for the 2nd, the 5th, and 6th of August. I did get to make up one missed day, and I went 25 days without seeing him. And one thing that tends to keep happening is, unfortunately, Abel gets sick, and that's understandable. People get sick, but whenever he's sick, I don't get my visitation time with him. And I am a parent myself, so I should be able to take care of my son. Like, there's no reason that I shouldn't get my visitation time just because he's sick.
Well, the problem though is you have supervised visitation, and the supervisor has to be willing to put themselves in a situation of being around a sick child. So I don't put much weight there, but I guess my question is, when I look at the bench order, and I'm gonna be perfectly honest, I'm not inclined to make drastic changes when I don't have another party present and we know why they're not present. But I want to be very careful here that I'm not going to be making changes. But I am looking at the bench order, and it states that if the supervisor, Ms. Woodage, is not available, that Mr. Llewellyn, your mother, may serve as the supervisor. So
My stepfather wants nothing to do with me, so I'm not allowed to go there, and it puts
Okay.
conflict between my mom and stepfather, so she won't do the visits unless he's gone. So that doesn't really work. I would like to ask, I've gone through so many hoops and I've done nothing wrong. Many people are going to testify to it. I went through reconnecting families. There's notes that not a single bad note was written, as far as I know. That's what they told me. I would like to request unsupervised visitation. I think it's time to let that happen, because I'm not getting any hours like I'm supposed to.
Well, again, you just heard me. I'm not going to be making that kind of ruling without the other party present. You haven't noted that issue for the docket. If you would like to file a motion with documentation to prove to the court in support of your position that you should be granted unsupervised visitation, please do so. That's what this docket is for. But you can't show up to a docket and make an oral motion without any evidence or notice to the other side and ask for that type of change. So you would need to file a motion with the court with documents. Okay. Mr. Lawrence, any further input from you on these issues? Otherwise, I think I'll probably set us out to October 11th at 9 a.m. For the next review, since that'll be after her release.
I have no further comments for today, Your Honor.
Okay. So that's what I'm going to do. So visitation is as remains in the June 8, 2023 order. We will set this matter on for review to October 11th at 9 a.m. Mr. Llewellyn, if you have a motion regarding visitation that you would like this court to consider, you may file it at any time.
Okay, Your Honor, so if I'm unable to get my hours like has been happening, is that just I'm stuck with that?
Well, all I can go off is the last judicial officer who held any sort of hearing on visitation had a backup option, which was your mother. And so if both Ms. Woodage as the supervisor and your mother are unavailable, then I don't have any other resources I can offer you unless you file a motion requesting a change to that bench order.
Okay, thank you.
Okay. All right. Thank you. You're free to log off. Do I have a Danya Rooney?
Yeah, I'm here.
Okay, Emerson, thank you. The name on the docket will always remain the married name unless you file a document to change it officially. So forgive me for using your married name.
Oh no, I appreciate that you're always on top of correcting it. Thank you.
And then Christopher Rooney, are you there?
Yes, Your Honor.
Okay. All right. So when we were here last, petitioner had requested some additional time to potentially seek counsel we did find that we would allow some additional time for that to occur to today. We did keep in place the visitation, but we did amend that slightly regarding the video calls. Where are we at now? I have received a declaration affidavit from you, Ms. Emerson. I guess let me first turn it over to Ms. Call to fill me in on maybe what's occurred since our last hearing.
Your Honor, I have not heard much from either party since the last hearing. I haven't heard from Ms. Emerson other than, unless I might be incorrect about that, Ms. Emerson, I apologize if I'm misspeaking, but I don't believe I've heard from an attorney or from Ms. Emerson since then, except for the declaration which I received yesterday.
You did receive that, okay.
Last night, yeah.
Okay. So Ms. Emerson, I'll turn it over to you to tell me where we're at since our last hearing.
I'm currently working with a legal aid attorney. She's just kind of helping me out with paperwork, filing, letting me know like what my options are, and how to proceed. I'm still waiting on a couple of other places to hear back as well to see if I can get additional help.
Mr. Rooney, what input do you have for the court?
I don't really have anything, Your Honor. I'm just ready for the whole process to be over with.
Okay. And I think Ms. Call, are you still working on a report for the court or?
No, the report has actually been filed. It was filed, I believe, it was filed on, sorry, let me pull up when it was filed. I apologize.
Oh, there it is, back on July 25th. Have both parties had a chance to review that report?
Yes, Your Honor.
Okay. Let me start with you, Ms. Emerson. Have you had a chance to review that report?
Yes, I have.
Okay. And have you reviewed the recommendations?
Yes, I have. I am not sure if you had time to go through my declaration that I had submitted, but I have been participating in a parenting class already. I have sought extra counseling. I actually received a copy of my son's paperwork as well for his medical records previously on the matter.
So I guess what I'm asking specifically, there are recommendations in the, well, let me back up here. When we were together last, you'd asked for time to seek counsel. Are you represented by counsel or are you continuing to proceed on your own?
No, I'm continuing to proceed on my own at the time. I just have the legal aid who is just assisting.
Okay. So when you look at the G.A.L. report regarding the recommendations for primary residency, visitation, decision-making, those sorts of things, are you objecting to them?
Yes.
Okay.
I'm sorry. I'm really not aware of how to do any of this. So I'm just trying my best and.
Yeah, I mean, so tell me why you're objecting to the recommendations of the guardian ad litem.
As for decision making, they have Christopher Rooney and I had agreed to have shared decision making, and anytime I have really given him the option, he might ask one or two questions, and then he's just like, "Do whatever you think is best." As for the living arrangements, it's been continuous in and out, just inconsistency. He actually has tried to prove that he has not been inconsistent. I am still actually currently working on some screenshots to show some of the said inconsistency. And I mean, my daughter has always been with me and my family, and she's essentially just been ripped away from her entire life.
Mr. Rooney, are you still with us?
Yes, Your Honor.
Okay. So as far as primary residency, visitation, decision-making, those things from the guardian ad litem report, what is your position?
I agree with the guardian ad litem. I do have a The question though, I wasn't served with this declaration that apparently was served last night, so I don't have a copy of that as well.
The declaration of Ms. Emerson, you don't have a copy of that?
No, I was not served with anything.
I sent it via email along with when I sent it to Miss Call.
So yeah, this was just on Monday. Did you send it to, are you saying you sent it to Mr. Rooney?
Yes, via email.
I received the declaration last night. Let me tell you about, it says 8:46 p.m. So if Mr. Rooney hadn't checked his email since then, he may not have it yet.
Sooner than that.
I am seeing it now.
Okay.
And it was also under my belief that somebody else needed to serve me, not herself. A party who is not currently or planned to be present during this court case.
Are you requesting that?
I thought that was already the motion. I thought that it was supposed to be someone who's not currently or
That is typical for service, but I'm just asking whether you're going to agree to accept this declaration. I'll give you time to look it over. I'm not asking you to respond to it on the spot here, but are you in agreement?
I'll agree to accept it this one time. I just to review it or anything. I have not checked my emails till just now.
Okay. So, I mean, technically what we are here to do is come up with your parenting plan based on the GAL report. I will, Mr. Rooney, give you some time to review this declaration. However, my inclination at this point is to adopt the GAL findings regarding visitation, parenting plan recommendations, etc. What we would need from you, Mr. Rooney, at our next hearing is essentially a proposed parenting plan that conforms with the GAL recommendations. Is that something that you know how to do?
That's something that I could get done.
Okay. And again, you probably heard me say this to another party. There are courthouse facilitators here that you can come. So you prep your final orders.
Hi.
And then you come in, you pay $20.
Good. Hey, can I get a...
You pay $20 and make an appointment for a subsequent Friday, and then they'll look it over so that when you do come back, you typically are in a position where you have the type of order that a court can adopt and or make slight modifications to.
Okay, Your Honor, I do have one question though.
Go ahead.
I would like to know if I have the 100% of the decision making right now. I would like to change schools for my daughter.
Okay. What type of change are you making?
I would like to move her to a different school up to.
Are you talking about out of district or?
Well, I do not currently live at the school that she attends. I don't live in that district at Barnes.
Right. So I'm asking you what district you live in. Are you talking about out of county? Are you talking, what are you?
No, it's still
are you talking about?
Still in county. It's just a different school.
Your Honor, this is Casey Lanu at the state.
Yes.
The state's understanding is that there's not yet been a finding of adequate cause to change the parenting plan. We were waiting for the GAL report. If a finding of adequate cause is being determined and we're changing the parenting plan, the state will be filing a notice of appearance as to child support.
The child's receiving some sort of state assistance?
That's correct. The child is on state medical.
Okay. Okay. Thank you for that. That is very helpful. I think I'm just trying to go back. The original motion was quite a while ago. And it looks to me like Ms. Looney's correct. What we have is just essentially a series of visitation orders, but we don't have an order on adequate cause to change the parenting plan. So she's absolutely correct that would be our first step here today. What I'm going to do then is I will normally, Mr. Rooney, I would have you prepare an order for adequate cause, but just for sake of time, how long this case has been going on, I will prepare an order finding adequate cause based on the GAL report to send this on for further hearing or trial on a new parenting plan. What I'd like to do in the meantime, because it does sound like time is of the essence, Mr. Rooney, is have you submit temporary orders that I can put into place that do give you that decision-making over schooling for now. So instead of presenting me with final orders at the next hearing, it would be you're going to submit a temporary parenting plan that we can put into place while you guys work your way through the hearing or trial on the final parenting plan. Does that make sense to you?
Just one question about that, Your Honor.
Okay.
Is that, so am I gonna be able to change school, because school starts next week?
Mhm.
Change schools before the next court date, or do I have to wait?
I'm inclined to allow that on an emergency basis at this point. Ms. Call, do you have any input on that?
I understand why Mr. Rooney wants to take her to a different school, in part because Your Honor, am I able to ask a question of Mr. Rooney?
Absolutely.
Okay. Mr. Rooney, is this due to after-school childcare? Because I know there was some concern about kiddo being in the same program with the person who she's alleged has hurt her. And so is this why that is where the request is coming from?
It's partly due to that, and also partly to do that I no longer live in that district. I used to live right next to Barnes School, but January I moved. And so I also no longer live there, and I want to set her up at a different school so that it's easier on me, and we can get things going, because my dad's a big help with cheerleading practice, all that stuff. And
Are you still living with your grandmother? Is that the location you're referring to?
Yes, still currently.
Your Honor, I would support a school move that got Myra somewhere where she wasn't in an after-school care program with her aggressor.
Okay. That does make a lot of sense. Mr. Rooney, what is the name of the school?
Kelso? I'm not quite sure what.
Is it a Kelso public school?
Yes. My other kids go there, so that would also make it easier for transport and stuff.
So what I'm going to do today is I will fill out the order finding adequate cause to change a parenting plan. We're going to set, how quickly do you think you could prepare a temporary parenting plan that aligns with the GAL report that we could have in place while you all work your way through the final parenting plan?
I could have it done within the week. I'm currently on vacation from work, so.
We could set you to, since I am going to include in this order the change in school, which I think is the most emergent thing. Why don't we set you to Wednesday, September 6th at 9 a.m. That gives you time to fill it out and serve it on Ms. Looney and on Ms. Emerson.
Oh, quick question. How do I go about serving Miss Looney? I'm not sure that.
I'll let her jump in if I'm wrong, but my assumption is you can bring it to the prosecutor's office.
That's correct, Your Honor. We're actually in a separate building, but we will be filing our notice to the parents. That will have our address and instructions on how to get paperwork to us. So that should come to him soon. We would also be getting a temporary proposed order in that packet out to everyone as well for that 9/6 hearing.
Great. So Mr. Rooney, we'll set you to September 6th. What we can do is discuss the temporary parenting plan at that time, the state's temporary child support orders, and then we can address any issues if they've come up regarding, excuse me, Ms. Emerson, if you have any further objections. But at this time, I am going to adopt the GAL recommendations for purposes of the temporary parenting plan we put into place.
And Your Honor, if the state just requests for each of the parents to contact our office, I can give them the phone number that we would request that they give us their current addresses so we can make sure we're sending the information to the correct place. We would also be asking for emails if they would accept documents by emails, but they can call our office number.
Okay, so reach out again, give them any contact information they need. We'll come back on September 6th for those temporary orders. The process from there will be determining if you all are ready to get put on for trial assignment on the final parenting plan, okay?
And Your Honor, I have one more question.
Yes, go ahead.
So I would like to change the time of the phone calls just because she's in cheer practice now. So Mondays, she has counseling, and then right after counseling, she has cheerleading practice. So I'd like to move Mondays to Tuesday at 3 o'clock, and then keep Thursdays the same date, but or we'll do 3:30.
I'm not going to address it today, but you can put it in the temporary parenting plan, okay?
Okay.
All right.
Your Honor, can
Oh, go ahead. Go ahead.
I wanted to highlight for Mr. Rooney the recommendation that the sexual assault parenting support group begins September 4th at 6 o'clock. And I would highly encourage him to participate in that, as well as getting the recommendation I made regarding making sure we have a sexual assault advocate for him and Myra as well. Just wanted to highlight that's coming up.
Yeah, and I think that's important since it's before our hearing date. So I appreciate you jumping in there. Mr. Rooney, do you think you need any additional information from Ms. Call to get those scheduled before we're back again?
I do believe that I have all the information on it, and I did line it up with my work so that I can attend these.
Okay.
They agreed to give me the time off, let me come in early or come in late.
Okay. Okay, well, we'll see you back on September 6th. I will get that order entered after docket today. Any other questions?
No, Your Honor.
Okay, all right. Thank you all. I appreciate it.
Thank you, Your Honor.
Okay, so when we were last here, we were addressing Mr. Fike's motion for contempt. We did deny that, but we did reserve ruling on the adequate cause motion to today. And then my understanding is also, if I am correct, Ms. Manley, you have filed a motion for contempt. Is that correct?
That's correct.
Okay. So let's first address your motion for contempt. I'm just going to go get your original motion here. Mr. Fike, have you had a chance to review the motion for contempt that Ms. Manley filed? It was on or about August 7th.
Yes, I have.
Okay. So Ms. Manley, what I see is one of your initial requests is back child support in the amount of about $5,850.
Yes, that will be paid to the state because I've been on TANF. So technically he owes the state that money.
Okay.
But I would like Mr. Fike to resume child support payments so I can get off TANF.
Mr. Fike, just as it relates to, hold on one second. I have someone messaging about some additional people in the waiting room. I'm going to let them in. So Mr. Fike, as it relates to child support, what can you tell me? Just as it relates to, all right, if you just logged in, please mute yourself. Go ahead, sir.
So as far as the child support, back in December of 2021, Anna sent in and signed a piece of paper to child support, which discontinued child support from myself. It was my understanding that this was the end of it. I do believe that she is just filing this because I filed for contempt. Like she said, she is on TANF, so she's not actually receiving any money. I know this was one of the reasons she stopped payment from me. So as far as I knew, it was already written off and done. I didn't know that I was supposed to call child support to resume so, since she had already stopped
it. So Ms. Manley, do you have something showing amounts from child support that are owed?
Yes. I believe it's 5,120. No, I don't know the exact amount.
No, I'm asking something, since it's not owed to you, that it's owed to, that child support is collecting it. Do you have something from them showing the current amount that's due?
I have it somewhere here, but I do not have it in front of me. The reason it got discontinued is because Mr. Fike was living with me. So I assumed that once he moved out that he would resume paying child support, but he did not.
Your Honor, this is Casey Looney with the state again.
Go ahead.
We were just looking into this case as Ms. Manley was speaking, and the state will need to be filing a notice of appearance in this case. So we'd be objecting to any discussion about child support at this time. It does appear that TANF is still active for mother and children. So we would need to be looking at what the support looks like and where those payments need to go. There are arrears owed to the state of Washington for TANF at this time.
Okay. I think that makes a lot of sense. And I'm glad you happen to be on docket for that, because it does appear, I guess what I'm going to say right now is, given the state's involvement and the issues with whether when he moved in that should have ceased and whether he moved back out, it should have resumed. I'm not going to make any ruling on, I'm going to reserve on Ms. Manley's motion for contempt, and we'll set that to a new date. How much time would the state want to get involved and present any position to the court?
Your Honor, if you could give us a minimum of 3 weeks, I would need to review the case and be able to draft proposed orders and get those out to the parties.
Yeah, let's go ahead and set the issue to September 13th. And then what I'm going to do is also set over the adequate cause showing to that date. So Ms. Manley and Mr. Fike, you're probably going to receive between now and September 13th. You're going to receive some additional information from the state on the child support issue. So please be on the look for that. If there's something you disagree with, please file something before September 13th, letting me know with documentation, if possible, why you disagree with it. Okay. All right. Thank you all for being here. Ms. Looney, thanks for your input.
Thank you, Your Honor.
Okay. We already took. Okay. So Mr. Serafine, I believe that when we were last together, so Ms. Carroll has filed a motion for adequate cause to change a parenting plan. You were to submit a objection, which you did by the end of business on our last day, although it's just a declaration from you. So let me start with this. You've now received Ms. Carroll's motion for adequate cause.
Yeah.
And a petition to change a parenting plan.
Yes.
Okay. You now have filed your own proposed parenting plan. So let me ask you this. And I've got a couple people jumping into the waiting room. What I have in front of me now, and again, I understand both of you are doing this without an attorney, so I'm going to walk through this kind of step by step. One of you has filed with the court a motion for this court to find there's adequate cause to send this case on to a hearing or trial on what a new parenting plan should look like. But then both of you have presented the court with new proposed parenting plans. Do you both agree that this case should go on to a hearing or trial on what a new parenting plan should look like?
Yes.
Okay, Mr. Serafine, what is your position on that?
The only change I want is I'd just like to see my kids like every other week, without supervision.
And you're currently seeing them just supervised?
Not right now. I haven't seen them since the court. I mean, I've seen them at her place. I went to her house, but not getting them like how I usually do.
Okay.
Take them places.
So let me ask.
Court.
Okay. So are you wanting to agree that there's adequate cause for the court to reconsider what the permanent parenting plan looks like I'm not saying whose parenting plan we'd be adopting. I'm just stating that first step of, do you believe that there's adequate cause for this court to revisit the issue of a parenting plan? Or are you objecting to that type of finding and asking this court to say, nope, the prior final parenting plan needs to stay in place?
Yeah, the prior.
Okay, so you are disputing whether there's adequate cause to reconsider the parenting plan.
Yes.
Okay. So let's start with that issue, Ms. Carroll. Ms. Carroll, on or about July 20 of 2023, you filed a motion for adequate cause to change a parenting plan. Is that correct?
Yes.
Okay. And then what would you like the court to know beyond what is in your motion as to the reason that you believe there has been a substantial change from the time the last parenting plan was put into place?
So I did provide with most of all the legal reports and findings of domestic violence that was occurring in the home. And then the abusive use of conflict is one of my other concerns. So before the relationship he's in with now, there wasn't any issues that I could come up with for the conflict of parenting plans. But since he has been in a relationship with someone, he's changed in a sense that I don't trust him with my children. He has agreed to go through, counseling and parental classes and things like that, which is awesome. But my concern is that they're still being exposed to domestic violence and manipulation tactics. And a lot of that, it's psychologically damaging all three of my kids. And so until I see adequate change and his circumstances, I don't want them with him without supervision. And so that is why I propose this change, because without it, I cannot keep them with me only or ask for supervision.
So let me just ask you this. A couple of the police reports that you put as part of your motion were, so your final parenting plan is dated October 5th of 2021.
Yes.
And then a couple of the reports were from prior to that time. So I can't consider those for adequate cause. But what I'm seeing since 2021 was an arrest for potential DV where Mr. Serafine was listed as the victim. Is that your primary?
That's part of it. I didn't realize all the domestic violence while I was doing the original parenting plan. So when I pulled those reports, it was basically off of circumstances of physical findings, scratch marks, bite marks, things like that. And then reports from friends that there was a lot of domestic violence occurring. So I didn't realize all those things were happening until I pulled the public records request.
Got it.
So had I known that prior, then I would have totally started with the original parenting plan being different.
And is Miss Wonderling, to the best of your knowledge, still in a home with Mr. Serafine?
Yes.
Okay. Mr. Serafine, I'll come to you in just a minute. Okay. Mr. Serafine, you're objecting to this court finding adequate cause to change a parenting plan. What would you like the court to know about that?
Okay, so the issues I had with my girlfriend, Miss Wonderling, that was like over a year ago, and we're doing, fine. We're just doing everyday life, going to work and everything, and hopefully to see my kids again. And there's times, I've for Miss Kimberly, Miss Carroll, there's time, I don't have them. I'll ask a request if I could get them so I could, do stuff with them. And she said, it's fine. There's times that I'll go out of my way to fulfill what she needs to be done because she's busy at work all the time. I know that. I get that. And, I would like to have my kids as much as possible. And as the domestic violence, that's, like I said, over a year ago, and we're doing fine. All that cases dropped. And the kids are happy. They come over here, they're happy every time they go home. I think she sees them because they have to be home. They like to stay at my place.
So
and then and she's worried about drugs and all this stuff. And I told her I'm willing to take a follicle test, which I did. And I took an assessment test, and I dropped it off today at the clerks today. I think they'll probably scanned it already on my results there about the alcohol and all that. I took all these. I seen a counselor for all these when I had that issue. So that's what is on that medical record that I provided.
Mhm.
Hopefully you will get. But other than that, you know, there's no domestic violence in front of the kids, like
Okay.
what she was saying.
Is Ms. Wonderleen still residing with you?
Yes, she is. She's, you know, her body's really, you know, she's got some medical issues right now. Her body's hurting. She just broke her leg, and she's looking for a job.
Okay. I have reviewed the police reports, and there are at least 2 incidents where probable cause was established that domestic violence had occurred between Mr. Serafine and Ms. Wonderleen. I do believe, in my opinion, that does allow me to make a finding of adequate cause to at least send this case on for a hearing or trial on whether the parenting plan should permanently be changed. We'll give you a review date in just a minute. My Ms. Carroll, in the interim, I know you did submit a proposed parenting plan. I'm not inclined to sign it as presented. It makes a lot of findings that I think we need to reserve for an actual full trial. But your primary issue in the new parenting plan on a temporary basis is to change to just supervised visitation. Is that correct?
Yes.
Okay. So what I'm going to do in this adequate cause order is I'm going to do a couple things right now. Until further review, supervised visitation with Mr. Serafine only. How often do you want that to occur? We typically would do like twice a week, up to 2 hours at a time.
As far as who would supervise them has kind of been the issue. I don't know who would supervise them other than his oldest daughter. I've offered for him to come over to see the kids at my home with my husband or myself present at any time to see the kids, however long he wants.
Okay.
But the friends that I used before during supervision with him, when we first got divorced, he burned that relationship. So I don't know who to trust unless he were to pay for someone to do supervised visits.
So yeah, Mr. Serafine, I guess I'll give you 2 options on this temporary basis until we can get you into a full trial. I am also going to appoint a guardian ad litem to help out with this issue. But for now, I guess your options are going to be whether you want to pay for professionally supervised visitation, or do you want to do that visitation at Ms. Carroll's home or in her presence?
I'll pay.
You're going to pay? Okay.
Yeah.
Supervised visitation with respondent only via professional supervisor. We'll say up to, that's going to be up to twice a week. 1 to 2 hours at a time. I'm also going to appoint a guardian ad litem to your case. Are any of those names that you wish to strike from a guardian ad litem on your case?
What was the second name?
Ann Height.
I don't know either one of those 3 people, so I have no objections really.
Okay. Mr. Serafine, any names you would be objecting to?
No.
Okay, we'll just assign the first on that list, which is Amy. Are either of you receiving state assistance?
I have state medical for the children.
Okay. What's your monthly income approximately before taxes and withholdings?
Mine?
Correct.
Before is 6,022 monthly.
And then how many dependents do you take care of on that money?
4.
Okay. Does your spouse work as well?
Right now, he's helping me with the kids as I transition. I'm actually stepping out of the role that has prevented me from being at home as much. Okay. So he's not working to help me with the kids in their schedules.
Okay. He's not working right now.
Right.
Okay. When did he last work?
He just did a job last month, so he's a general contractor, so
Okay.
he can pick and choose when he wants to work.
Okay. How much did he make last month approximately?
Probably maybe 4,000.
Okay. And then Mr. Seraphine, what is your monthly income?
It's ups and downs because I work in pretty much a commission.
Okay.
I'm an artist.
What would be a low month and a high month?
Low, I'd say probably around 3. It's been really slow.
And then what about a high month?
4.
Okay. So what I'm inclined to do, both of you are beyond the limit where I would appoint a GAL at county expense. I think given looking at your incomes, but also taking into account, well, Mr. Seraphine, how many people do you support on your income?
I'm paying child support still right now, so I'm paying like 250. So pretty much like almost 850 in child support.
Okay.
That's not including the one prior with Turb, my first.
Okay, I'm going to appoint a guardian ad litem. The two of you are going to split the cost. Ms. Carroll, you're going to be responsible for 60% of the cost of the guardian ad litem. Mr. Seraphine, 40%. I'll get that order filled out today and the guardian ad litem will be in touch with you. I want to set a review date. We've changed the visitation until we get more input from the guardian ad litem. Let's set this out about 30 days. So you all have had some contact with the guardian ad litem by then. And I do think you supplied orders, so give me just a minute. Mr. Kamba, did you receive the proposed contempt order that Ms. Kamba filed?
I did.
Okay. So, first, I'm just going to start out by saying, Mr. Kamba, it looks like you have filed a motion for contempt that you've set on our September 6th docket.
Correct.
So we're not going to hear that today because that is now set for September 6th. What I have on my docket today is a request for contempt based on about $4,000 owed for past child support. Is that correct, Ms. Kamba?
Yes.
Okay. So, Mr. Kamba, I did see your response that you're having some of this withheld from your check.
Correct.
So what else can you tell me? That was just, you submitted about 2 sentences in support of you being in compliance with child support. What else can you tell me?
Well, a payment was made, I believe, on the 19th. That was taken out of my paycheck, and so I'm not really sure what it is that she's trying to get out of here. Yeah.
So, Ms. Kamba, you're alleging that since, at least according to your motion, since November of 2021 to June of 2023, that Mr. Kamba hasn't paid $225 a month?
Yeah, so we went and got about 2 years ago, he assaulted me, and we finally just got all of that done in the end of May, beginning of June. And they gave him orders to start paying child support, and he owed back child support from November. And then he said when we were in court that he had a job. And so I waited and waited, and June came and we finished up court and he still didn't pay. And I brought that to the court's attention to make sure that he is not waiting on proceeds of the house. And the judge at that time said that no, he is supposed to be paying. And so then I put in more orders because he obviously did not pay me. And looking at my account right now, there's no money in there from DSHS and they have my information. So I messaged the guy who's representing us. His name's Daniel or David, something like that. And the last thing he sent me on August 15th was there was no payment received from him. So I'm just asking that we put the supervised visits on hold due to they cost money. And if Mr. Kamba is already behind with one child, Mr. Kamba also has 3 other kids he needs to probably pay child support for too. So I think that putting him in jail isn't going to help and giving him more fees isn't going to help. So if we put these visits on hold, hopefully then he could get caught up on child support for all of 4 of his kids.
Mr. Kamba, there is a June 2nd, 2023 order for support that was issued for $225 a month, dating back to November 2021.
Yes.
So what can you tell me about your attempts to start paying on that?
So I had given my previous employer the information for taking out child support and the notice about that. I contacted the child support payment agency, and they never reached out at all. And then so I figured, okay, well, I'm in the middle of switching jobs, so I just got another job, and still nothing was done about it. So I had to, get a hold with them. So I've been in contact with child support.
Okay.
And they finally were able to get the information from my current employer to be able to have the withholdings, and they said that they should be taken out of this next paycheck.
Okay.
So my last paycheck was about $300 shorter than what I would normally get.
Okay.
And so they're taking $100 out on top of the $225 that were put on there, and so I'll be paying $100 extra on my back child support, and then the original payments of $225 a month.
Okay. So let's do this. I'm going to give you, since we already have a court date set on September 6th at 9 a.m., I'm going to reserve ruling on this contempt. What I need by September 6th is some sort of documentation from you or the state or your employer showing that you are making progress on this. If I don't see that, then I am going to entertain a motion for contempt. I likely will make a finding of contempt if there's no payments made by September 6th on the back support. I'm not going to withhold visitation for child support, but the other tools the court has are not ones that you're going to love. So I really recommend that by September 6th, sir, you have been making payments on those support amounts.
So they had the wrong information for my employer, so I couldn't do anything about that.
So you're going to have to fix all of that, and you're going to have to have made payments by September 6th, or I will, in all likelihood, make a finding of contempt, which usually does include interest. It can include jail time. So I would prefer not to go down that road. I would really encourage you to start making payments on that amount.
Okay, so can I make a payment today, and then
Please make as much and as many payments before September 6th as you possibly can. Ms.
Okay,
Kamba, what did you want to say?
Is there any way we can move court from the 6th to the next following week?
Mr. Kamba, would you be in agreement to put this to the 13th? That would give you more time to be making payments.
Well, I mean, like she said, I have 3 other children who are, of older age.
I'm asking you, we're running short on time. Can you move to the 13th, or do you want to stick with the 6th?
I'd like to stick with the 6th because I wasn't given very much notice for this court date. So I'd like to stick with the 6th if possible.
Ms. Kamba, is there a reason you can't participate on September 6th?
Yeah, our son has a medical appointment in Portland that took 3 months to get.
What time is that appointment at?
9:45.
Okay. That does run directly into this court date. So Mr. Kamba, that is good cause to move both of your court dates. It's your child. So Mr. Kamba, I'm going to move your show cause motion and review of the contempt to September 13 at 9 a.m. Okay. So when we were here on June 28, we did approve child support orders. We set review to August 23rd. My understanding was we'd be reviewing treatment progress and further visitation issues. So maybe I'll start with Ms. Fellows as the G.A.L. to let me know where we're at.
Yes, Your Honor, thank you. I have not received any compliance reports from the father's DV treatment or the parenting class. I did call this morning up to alternative counseling.
Okay.
And inquired about whether or not dad had signed an ROI, and they indicated he has not. And that was a big issue, that he was supposed to sign the ROI when we were in court last. So that way I could get compliance reports.
Mr. Kiyoshi, what can you tell me about release of information and any compliance with treatment?
I'm halfway through my parenting class, and for the ROIs, I did sign ROIs. I'm doing the DV treatment right now through Best Life Services. That's happening every Wednesdays, 5 to 6. And then my parenting class, I'm doing every Tuesday, 6 to 8. And that's with Family Education and Support Services. ROIs were signed. She is on the paperwork. I don't know why they haven't let her know that I'm in compliance. I've been taking the classes.
Okay. Ms. Fellows, were you aware of the places where he was doing those? I guess my concern is maybe he hadn't communicated that information.
No, he has not. I have not had any communication with the father. And when we were in court last, he did say that he was going to be in DV at alternative counseling in Olympia, which is who I called. So I had no idea that there was a different facility or provider, and have no idea who that parenting class is either. So there's no way for me to know and be able to contact them.
Completely understood. So Mr. Kiyoshi, I'm going to give you some homework before our next review date. And when I say that, I mean, like, do it this week, even if our review date's a few weeks out. Get a hold of Ms. Fellows and get her the names and your schedule, so the names of the agencies and your schedule for the parenting and the DV courses. That way she can actually contact the correct agency that you're getting treatment through. And if you have signed those ROIs for her, then she can get those records and we'll review it when we're together again. So we'll set a date here in just a minute on that. So that'll be your homework, but keep going to the classes. It sounds like you are enrolled. That's all good news. So keep doing what you're doing on that front. Do we need to address visitation right now, or how is that working? And I'll turn to you, Ms. Vaughn.
So as of right now, I don't feel comfortable giving him any sort of unsupervised until we have those reports.
Correct.
Which was addressed last time and countless times before. We've been sitting here with just this DV issue since January. So it's really important to me that that is squared before we go any other direction. Right now, Tuesdays with his at a parent's place, his 2-hour visits are working just fine, and it doesn't really affect either of our schedules too much. The calls on Wednesday nights still haven't been going great. Like, they've just not been good for a few months now, but what can you do? I guess I'm kind of tired of repeating myself over and over about how the video calls have tanked in quality over the months. So I'm just kind of doing them.
Yeah. And do you mean Mr. Kiyoshi and how he's relating to child or to you, or what do you mean when deteriorating?
It's only with child. And so, like, for an example, since you weren't here back when this all began, there was like the month of December where he did really well, like exceeded expectations with visitation. He was finding toys that he knew my son had the same ones of in our home and would play with him, interact through the phone that way. And the calls would be 30+ minutes long, sometimes up to an hour, when he was only necessarily supposed to be given 15 minutes. So I was very happy to report back then when things were going super well. He'll do this thing where he'll do good for a little bit and then it'll tank. And it just seems like it hasn't picked back up. Most of these calls now have been like maybe 5 minutes at best. He called my son a few weeks ago from the river even. And I was like, that's kind of rude to show my kid that he's missing out on this fun with you because you're not doing what you need to do to have him unsupervised. And I mean, he's about to be 3 years old in just a few weeks. So he doesn't really comprehend that, but he will eventually. And these are the kind of things that it's supposed to be a distraction-free environment for both him and I with this visit. And it just hasn't been.
Mr. Kiyoshi, what do you want to say about the video visits?
So I've been saying this since the court allowed video visitations. I can't get good quality time with my son, and that's been a problem since we started the FaceTime videos. I do it because the court allows me to do it. But now that I have 2 hours every week, which is still not enough to have quality time with him, he'd rather have me spend time in person with him than over a camera where I'm asking him what he's doing. He's running around. I understand that. I mean, I'm grateful for the FaceTime visits, but there's not a whole lot I can do over a camera. And I've been saying this since the beginning.
So I guess, Mr. Kiyoshi, are you asking to continue with video visits?
Yeah, because it's the only way I can see him for now.
Okay.
So yeah, the quality isn't good, but he gets to see my face, and okay. I want him to know me.
So I'm going to be really clear. We're going to set a review date. I'm not going to change any in-person visitation. It's going to stay as is with supervised because I don't have any of those reports right now. Let's set you all to September 27 at 9 a.m. And that's a little more than a month out. so that Ms. Fellows can get those reports and have a chance to digest them. When we come back, we can talk about what that compliance looks like. When we come back on the 27th as well, I would like to, as Ms. Vaughn noted, I have not been the judicial officer on this case for a very long time, so I don't know a lot of the history with the video visits. I'm not going to issue an order on them, but what I am going to say, Mr. Kiyoshi, is it behooves you to make those as productive and comforting to the child as possible. I understand it's not your preferred method of engagement, but it's still very meaningful to the child, no doubt. So I would like to, when we come back, and you know, an idea I had is, why don't you maybe Google some ideas of things you can do with a kid over video calls, have games that you can perhaps play with the child when you're engaging over video, so it doesn't have to be mundane. So just try to get creative and make it as effective as possible. When we come back on the 27th, we'll revisit how video visitation is working in conjunction with the other compliance notes we review. Okay?
Yes, sure. And I have one more question.
Go ahead.
Is there any way I can get this, Bedfellows can reach out, or I can reach out to my, whoever I'm getting this treatment from, so she can get an update on everything, so that maybe I might be able to see him and have him for his birthday, which is coming up next month?
So what
I missed his first 2 birthdays. I'm not trying to miss this one.
What day is his birthday?
September 23rd.
I won't be able to get you in for a review. Ms. Vaughn, is there any thought to allowing any sort of supervised visitation on his birthday at least, or what's your thought?
So actually, his birthday has been an issue the last 2 years, and not because of this. This has been the first year that it's actually gone well, because of the fact that we've had this separation between us. There isn't any place that will do visits on Saturdays here. I have his party already fully planned out, everything set for his party. The first year he showed up here from Colorado, like unannounced, unwelcomed. He had the whole DV thing had just happened. He abandoned me and my son. It was a big issue, and he showed up and literally ruined my son's first birthday, completely yelled off the birthday.
Yeah, here's what I'm gonna say, Mr. Kiyoshi. I understand. I'm keeping your review date September 27th. Unfortunately, that's not going to work out for review before the birthday. The closest, the best I can say, is the closest supervised visit you have to his birthday. Make that your birthday time with him. That's the best I can offer given the history of this case as I'm reviewing it. Okay. Maybe we'll be in a different position going forward after one. Okay.
Yes, Your Honor. Okay. So one more thing. Sorry.
I have to move on. You guys have your court date for September 27th at 9 a.m. And then Mr. Kiyoshi, please do reach out to Ms. Fellows with the names of the agencies so that she can get those reports for our next hearing. Okay.
Okay. Can I just ask one more question?
Quickly.
Quick. It's going to be quick. So the next closest visitation I have, can I bring my nieces so they can see their cousin? It's still a supervised visitation.
Does supervise, is it professionally supervised right now?
Yes, I drive to Kelso.
Do they allow that? I just don't know. Yeah, here's what I would recommend, Mr. Kiyoshi. Reach out to the supervisor and ask them. I'm not going to make a ruling on that because I just don't know what their policies are.
Yes, ma'am. Thank you.
Okay. All right. Thank you both. Ms. Young, can you hear the court? Thank you, Ms. Fellows. While we're waiting on that, Mr. Lawrence, I'll just ask you, were you able to get a copy of the proposed temporary parenting plan?
It was, Your Honor, and it looked fine. They did not leave a signature line for me, but I'm in agreement with it if the two parties are still in agreement with it.
Okay. And I will, Mr. Utter, let me get your, I'd like Ms. Young to be able to hear us. I'm going to just ask her to unmute here and see if that triggers any response from her. Okay, it sounds like that might be an agreed order. Mr. Lawrence, I hate to keep you longer, but I'm going to go ahead and call another, what I think will be a quick matter while we wait to see if she logs in.
That's fine.
Okay, thank you for your patience. I'm going to skip ahead to Gibson.
Yeah, I'm here.
Okay. Let me just jump into your digital file here. This was, I believe, Mr. Kilpella's motion to send this case into mandatory mediation. We were here last and I struck the hearing because we didn't have service. I see that is ServiceNow. But I don't have any specific response from you, Ms. Gibson. What is your position on mandatory mediation?
So I've tried filing a response 3 different times. The first form that I responded with, I requested a protection order. The lady told me that the form that I had filled out could not be filed under family law, so I had to refile under different forms. I sent those in last week, and I still haven't heard back with a review regarding the papers that I had submitted.
Yeah, I don't have anything. What I'm going to do, did you file so let me just make sure I understand. Did you file a response in the family law matter now, but you just did it recently, so I don't have it yet?
I responded, so the form that I had submitted, let me just grab it real quick. I have everything in front of me. I'm so sorry. I responded with the form FL Parentage 332. Shortly after being served his paperwork, they would not let me submit my protection order form P001, so I had to submit 3 forms. I think it was on the 17th or 16th that I submitted these 3 other forms.
So especially since we're running out of time on this docket, let me ask you this. Are you objecting to the transfer to mediation?
For visitation?
So to work on a parenting plan?
I'm not opposed to that. The only thing I would request is that he gets supervised visits.
Well, so I wouldn't be making that decision. All I would be doing today is addressing whether to send you all to mandatory mediation, or you certainly can discuss that with the mediator.
Okay, perfect.
Okay.
I would like that.
What I have here on his proposed order is that you each would pay 50% of the essentially you'd be splitting the cost of the mediator.
As of right now, I am unable to do that. I've been looking for work, and so far my availability is a problem regarding me needing to work around court matters. It's hard to find a job that's willing to hire me with those accommodations that are needing to be met.
So do you have any household income right now?
No, I do not.
Okay. I did get an email from them about their charges. So my understanding, if this is the same organization, is that the charge is $310. So do you believe you'd be able to split that? Would you be able to pay 50% of that?
I can try to do that, yes.
Okay.
I'll pay for all of it. That's fine.
You're willing to pay for all of it, sir?
Yes, sir. Yes, ma'am.
Okay, no problem. I'm going to go ahead and just make that one change. I appreciate you being agreeable to that. I think that short circuits me having to make a ruling on it. So petitioner will pay 100%. I'm just going to initial that one change on your form.
Okay.
And then, ma'am, I'm going to strike out your portion.
Okay.
We'll get this transferred over. I am signing it now. And I'll get that filed with the clerk. And then when you all have done that mediation and are ready to come back with either a proposed parenting plan based on mediation, or there's still some small points of disagreement, one or both of you can note it on for docket. Okay. 08. We set this over so that Mr. Lawrence could take a look at the proposed temporary parenting plan. I do have the original one that you both signed, Ms. Young on August 12th, Mr. Utter on August 14th. Mr. Lawrence did give his input. I'm not sure, Ms. Young, if you were able to hear that, that it does look agreeable, and according to the parties still in agreement to enter this as your temporary parenting plan.
Yes.
Yes.
Okay. I will go ahead and sign this as your temporary parenting plan today. I really appreciate the two of you working together on this. Let's set what we'll need to do in your case. And let me see, is there state involvement on this one? I don't think so.
No.
Child's not receiving any state assistance?
No.
Okay. What I'm going to do then is set a review date So we have the temporary order in place. Ultimately, we'll need to work towards a final order. You all can decide whether that's also going to be agreeable down the road or whether you're going to be requesting a trial or hearing on that. How far out, Mr. Lawrence, would be your recommendation to go on a review now that we have this temporary plan in place?
I think we should have a pretty good idea within 30 to 60 days, Your Honor.
Okay. Since I just set a bunch of cases to September 27th, trying to be mindful of how long these dockets get, and because it looks like the parties are working really well together, I have less concerns about getting them back super quick. What if we do October 4th or October 11th as our next review date?
That works.
Do you have a preference?
The 4th would be fine.
Okay. Mr. Utter, does October 4th work for you at 9 a.m.?
Yes, it does.
Okay. And Mr. Lawrence, does that work for you?
Yes.
Okay. What we'll do at that time is essentially, I'll call it a review hearing to see how the temporary parenting plan is going. And then we can discuss our plan from there as far as finalization of your case and setting future dates.
Okay.
Okay. Thank you both for working so well together.
Thank you.
Thank you.
Thank you, Mr. Lawrence, for your patience on this docket.
Thank you.